and welcome to Jane's LME Addiction, a Cloud 9 Fin podcast where we talk about all things liability management. I'm your host, Jane Komsky, head of LMEs here at 9fin, and with me today is Jason Mudrick, founder and chief investment officer at Mudrick Capital Management, and Aiken partners Dan Fisher and Jason Im. Dan is the co-head of the Capital Solutions Group, and Jason is the founder, is the head of the finance group. Thank you guys so much for joining me.
Thanks for having us.
Thanks.
And so the topic of today, and the reason I brought you all in here, is to talk about DQ lists. And so I guess I'm going to start with you guys from Aiken and ask, what are DQ lists? What are their purpose?
Yeah, and thanks, Jane. So before we get into DQ lists, I think you need to take a step back and note three things. First, DQ lists are only applicable to credit agreements and not to bonds and securities. Second, DQ lists are applicable to New York governed credit agreements. And so we know that in the UK, they have a regime where it's a white list rather than a black list. And then third, outside of the DQ list, agents generally have consent rights over assignments to non-existing lenders. Oftentimes, there'll be qualifiers like not to be unreasonably withheld or in their reasonable discretion. So you have to think about it within that scope of DQ lists. Now, when you think about DQ lists, I think there's really three things that have come up recently that have been sort of more aggressive from the company side and under sponsor docs. The first is who can be on those DQ lists. Second is what is the application of those DQ lists? And third is the ramifications. The first is oftentimes DQ lists on who can be on there. It's often competitors or lists that's provided at closing. With respect to competitors, it's customary that those can be updated after the closing date. What has happened is that about 42% of credit agreements now allow for the sponsor to update that list after the closing date. And so that has become a real hot topic of discussion. The second thing we've seen is that oftentimes those DQ lists should be specified in terms of what funds should be on that DQ list. Now we're seeing broader language about opportunistic or distressed or loan-to-own strategy funds, which is where it's ambiguous who's actually on that list. Second, in terms of the ramifications or the application, oftentimes with the DQ list, there's a provision that says you can't apply retroactively the DQ list. So if you add someone on DQ list, it can't happen retroactively or pending assignment. And without that language, what we've seen is putting existing lenders on that DQ list as a tool for sponsors to interact with their existing lenders. And then the third part is what are the ramifications? The basic ramification is if you're a DQ lender, any assignment to you is null and void. What we're seeing now in more credit agreements are the company can actually force those DQ lenders to sell their loans. And sometimes it's just at par or the price that the DQ lender purchased the loans. But now we're also seeing it at the trading price. And so when you put all those three things together where you can add on to the DQ list, you could apply retroactively or pending assignment, and you can force them to sell, that's really the tools that people have seen in the market in terms of where sponsors haven't used it, but it could be used and it's in these documents.
And taking a step back even, these DQ tactics are an understandable reaction and use by sponsors in the pendulum that the credit markets exist in. So it's similar in many ways to the provisions around LMEs in these documents. It's similar in many ways to the attempts for anti-co-op language to come in. This language that the companies and their PE sponsors are using to influence, coerce, cajole lenders, current or prospective lenders and their advisors to act in a certain way, typically to go along with and form a required lender group to do transactions the sponsor wants, or to stop them from organizing against a transaction the company wants. So it's, what Jason gave is, the correct technical answer. And those are words that have been in these credit agreements for a long time. But these provisions, along with others, are now being used by sponsors. I don't want to say weaponized because that is too pejorative. The sponsors are acting in accordance with their fiduciary duties to maximize their returns to their LPs, just like we as creditor advisors and creditors are acting in accordance with our jobs and duties. But they are being used by sponsors in the great game of, how will I get my lenders to do what I want, to extend my runway, to get more discount, et cetera? That's kind of the way I think we should place this in context now. And along with the anti-co-op or anti-agreement language we saw in Warner Brothers and others, and the LME type language, good or bad, we're seeing in a variety of credit agreements. That's the way I think I would place this language.
Yeah, look, I would, just to level set, and I think Jason mentioned this, but you have to understand the history of these things. There's an industrial logic to have a borrower have reasonable consent rights over their loan. You don't want your competitors buying up your loan.
And getting information, especially getting information about you.
Exactly. But the reason we're talking about them has nothing to do with that, right? The reason we're talking about them is because whether you call it weaponized or other, they've started to add market participants, not competitors, namely distressed players like our shop, that people say, well, I don't really want you in our credit because you may not be as friendly as, for example, a long only. So I'm going to put you on the DQ list. So that's why these have become so topical, because DQ lists used to have no names, then they had 5 names, then they had maybe 8 names. And we've seen a situation recently, which was highly unusual in Pretium, where they added 100 opportunistic/distressed creditor groups to the DQ list.
Yeah, so there's a lot there that I want to come back to, but I guess my first question is, Jason, as someone whose firm has been on the DQ, on various DQ lists, one, how do you find out that you've been DQ'd, especially if it doesn't happen because we said initially it happens at the primary issuance, but other times it happens not retroactively, but they can put it in at some point. So how are you notified that you've been DQ'd, as the cool kids would say?
Usually you don't find out until you go to close a trade and they deny consent, right? The DQ list isn't often a public document, right? It's public to the lenders of record, but if you're by definition, if you're not a lender of record yet, you go to become a lender of record, you find out you're in the DQ list. Sometimes the DQ lists are made public. You read about it. Oh, we're on the DQ list.
So that's right. So what is the reaction when you find out that you've been DQ'd? You've already done this work. You want to get in on the investment. Are you like, okay, that's reasonable? Or is it like,
I think that's a great time to pivot a bit back to sort of the ramifications that Jason talked about, because you need to understand in practice how this works. Like, the reality is DQ lists don't stop many distressed players from purchasing loans. It may stop the loan from closing, but from us becoming the quote unquote economic owner of the loan, we can trade on what the industry calls participation. It can be a swap, it could be an actual derivative arrangement with the bank intermediary, or it can just be like you purchase a loan and you just agree you're going to settle it later and it never closes.
Because unlike bonds with, unlike securities with settlements that's T+3 or T+1, loan settlement is not dictated by the law.
We have a loan on our books that we purchased 7 years ago. It's not in our name still in Neiman Marcus. Right. So you have to understand in practice the way this plays out, which is why I never quite understood the rationale for DQ lists. Because if you think about what they do, in theory, you're reducing the liquidity of the loan because you're removing market participants from the market. Okay. So that is hurting the original lenders that financed your, let's say, buyout. Okay, the traditional lenders, and it's an iterative game. These are the same lenders that are going to be looking at your next deal. If you're the private equity sponsor, and your deal after that, you're telling these par lenders or CLOs or others, right when things start to go south, we're going to reduce the liquidity of your loan and make it harder for you to get out. Okay, so that's one. So that increased the cost of capital. Okay, what else does it do? It makes it harder to effectuate a deal. Okay, let's say you actually get to a deal with, let's say you're trying to do an amend and extend or an LME. You get to a deal with the economic owners, and that's a key point I'll come back to. Then you have to go effectuate it. So now you got to run to all the upstreams that haven't closed their deals. And I can't tell you how many times you guys...
And the derivative and the derivative and the derivative.
Right. It's like you get a deal and you're trying to close it by Friday and nobody knows who's like, now you actually need the lenders of record to sign.
When Jason had to close the first travel court in the fall of 2020, we had to close we had to settle 2 years worth of trades and $4 billion worth of debt in like 3 days.
A lot of that was ours because we had DQs.
Yeah. There were a lot of emails on that deal. Let me tell you that much.
Yeah. So you're making it harder to effectuate a deal. And the reality is, let's just say there's, par lender, not to name a name, but original lender who's now exited the loan, hasn't closed. So XYZ par lender is still the lender of record, but we're now the economic owner, or some consortium of distressed guys are the economic owner. When an ad hoc group of creditors gets put together, it's the economic owners that join the group. Like when Aiken forms a group, or when Gibson forms a group, or Davis Polk forms a group, they don't ask us to show all of the loans that we've closed. They say, represent to us how much.
Give us a number. Give us a number of these people.
We say, we own $80 million. Okay. So at the end of the day, the sponsor's negotiating with us either way. they're not going to Fidelity or Franklin or whoever was the original lender. They don't care. They have no more economic incentive in the outcome. Okay. Will they execute a signature page if directed to? Yes, but they're not going to come on the committee and negotiate on something that they're not the economic owner of. So what are you really accomplishing? You're not preventing guys like us from getting in your capital structure, but you are hurting the people that finance your deal, increasing your cost of capital, making it more challenging to effectuate a deal. And you have to ask, what are you really getting for that? And I would argue you're not getting much.
And I think, Jason, you're also drawing more attention to the situation. Pretium, everyone knows what happened in Pretium. We saw the same thing in NEP, where Carlyle put 50 funds on the list. And it just is drawing attention to a situation. People ask what's going on, why are they doing this? What am I missing? Because as you say, there's limited real world impact sometimes. So is there some angle here that we're not seeing? And it just makes more, there's more friction for everyone.
Also, if I want to be Machiavellian about it, I actually like the fact that my ownership is disguised for some period of time. Right? Like if I'm accumulating loans, I don't necessarily want the sponsor to know that we're about to get a blocking position or some meaningful position that could, force us to be at the table. Right. So, if I was closing every trade, like it's kind of like keep your friends close, but your enemies closer. Like when you want to know that we're at 5%, we're at 7%, we're at 10%, you could arrange a meeting and say, and get some body language. What are you trying to accomplish here? What's your end game? You may not know until we have 34% because none of the trades have closed.
Right. And so, so both of you mentioned deals that I want to dive into, I think, a little more deeply. One is NEP Group, which was a Carlyle-backed company that you now said there are 50 there are 50 firms DQ'd. We had last heard like 36. But so this was a name that your firm, Jason, was DQ'd from, and you guys represented the term lenders or are representing the term lenders. And so what were the lenders saying to you when they found out that there were so many people on this list? If they were looking to trade out, what were you advising clients at the time?
Look, so, without getting to any advice we gave specifically, right. It was posted to the data room. We were just kind of like, I wonder why they did this. The amend and extend we did last year was completed. There was no active transaction. There were no active discussions. It just kind of showed up. So people were just basically confused. I think Pretium maybe is a little bit different, but there people just didn't quite understand why it had been done. And in retrospect, what happened was Carlyle, I think, added a bunch of names, didn't take any names off. So there were some names on that list which are no longer in business, certainly no longer in business as distressed funds, but were sort of on an original list from 2016 or 2017. And so it just was a little bit met more by confusion, making sure there's nothing we were missing. There was nothing Machiavellian. There was not in that case. There was nothing nefarious. It was just sort of what was done, and people moved on. But it definitely got people's attention, which may or may not have been the intent.
Right. And the same with Pretium, right? That was an 100 lender DQ list, which, I think everyone in the market universally thought, that feels extreme.
How would you feel if you're one of the original lenders and you're still on that credit and you find out like every single potential purchaser of your loan from you in the secondary market is DQ'd?
Yeah, so it seems like it's really just a tactic for the sponsor to say, well, we're going to choose the parties that we want to negotiate with, that maybe we do have maybe our company is not as distressed as you might think, or maybe it is, but either way, that basically we're going to look for BSL pricing as opposed to having the private capital, but we're going to get to choose our parties.
Yeah, but if you're truly distressed, okay, out of court, in court or out of court, so out of court, LME, A&E, you need to deal with the economic owners, right? I could see an argument where if you're slightly stressed and you're working on some sort of amendment and it will be easier to get that consent from a long only and you don't want to deal with distressed guys who might try and hold you up. I could see that argument, but the convention in the market is when you trade on participation, once you're the economic owner, even if you're not the lender of record, you're supposed to take direction. So if we say vote XYZ this way, the convention is you vote it that way. There's exceptions. If a bank's an intermediary and you have some clients that want to vote no and some clients that want to vote yes, you could see a situation where they have to choose. But in my 25-year career, I've actually never seen a situation where Goldman said, I'm not taking direction on your vote because we as an institution don't agree, or there's other people that own more than you that don't agree. Like we all end up agreeing on what's in the owner's economic best. It would be more of an academic exercise to come up with a situation where somebody's not going to take direction on a vote.
Jason, in the credit agreements, I guess lenders of record are allowed to vote some of their loans for and not all the loans for an amendment, right? There's no requirement.
That's right.
Yeah.
And so, Jason, I have another question for you, which is that, bringing up the situation of Tropicana, right, where it was in the 2L agreement that they didn't name any specific lenders. They instead just said that you can't trade with any lender who is a distressed fund or or primarily a loan to own fund. Is that, when you're advising clients, is that better to have that ambiguity, or is that giving the sponsor that much more power because they can turn around and just say, actually, we don't like this fund. We don't want to deal with them.
Yeah, I think it creates uncertainty, which I think gives creditors nervousness, right? Because you don't want to be involved and spend the time to be party to something where they could come back and use that as leverage. And so I think that ambiguity, it raises a lot of concerns in the creditor community.
And then where do you guys push back on that language? Like, is that in the primary issuance? Is it sometimes amended in?
So, we at Aiken obviously represent creditors all day. It's the core of our practice. We don't do a lot of primary issuance in the BSL market. And you don't see as much, this is not as much of an issue in private credit. But where we do see it is when there are amendments happening, sort of what I'll call more benign amendments in the BSL market. You look at a list of things, you try to shut down LMEs, try to shut down baskets. More and more people are looking at these provisions saying, let's at least clean up these provisions, because even if BSL primary issuance convention is this loose, wide open for the sponsor, here we can shut it down a little bit to make sure, as Jason said, there's liquidity, there can be trading. So this is sort of on the list of things we look at when we're going to amend documents.
Yeah. And so, Jason, if you were looking at a document like Tropicana, is that something that you would say, like, that your firm, oh, we're definitely included in this? Or would you say this is worth buying up? I mean, or there's no hard and fast rule?
We're actually one of the largest lenders to Tropicana. Oh, okay, I don't even know if we're on the DQ list. Like, we were on the steering committee. We did a transaction. I think it was a transaction that Pi and Pepsi thought was constructive. It never even came up whether we were on the DQ list or not. I mean, it's really like,
yeah. So when is it relevant? When is it?
That's what I don't understand, why there's a focus on it, because I do think it harms the company and doesn't accomplish what the sponsors are trying to accomplish. It doesn't stop true distress guys, the people they really want to keep out of their credit. We don't even think about it. When we find out we can't close, we don't close. But they can't do anything. There's no remedy. We're not a party to a contract. That's the whole point. They haven't closed the deal. And if they do close the deal, like, they're probably in default. So they're in breach just as much as we might be. But and by the way, the agent has no liability.
And sometimes when the companies are in default, those provisions fall away or get loosened.
In the old days, as soon as you default, all the consent rights go away. I think some documents now still, but like, at the end of the day, what are you going to, like, let's say it converts to equity. You're not going to let the person, like, at some point it has to close. There's like a new board, and it's the people like you that were allowed to close. So eventually it's going to close. You're just creating an administrative hassle. And I don't think you're accomplishing what you're trying to accomplish.
So I haven't actually seen this anywhere in documents, but I've started to hear that sort of the Yank a Bank is the enforcement provision, that basically they'll have language in there that says, like, if you're a DQ lender and the sponsor finds out that you're in the name, then you'll be forced to sell at either whatever the lowest of par, what you bought the loan for, or I think there was a third option.
Trading price.
Yes, or the trading price, whatever the lowest of. Have any of you guys seen that in the documents? Or
so I think those terms are pretty prevalent in the documents now. I don't think we've seen anyone actually use that Yank a Bank.
But that wouldn't be for a participation. That would be if you actually somehow were allowed to close when you were on the DQ list.
Right.
You shouldn't have been allowed to close.
That
might be litigated, though.
Yeah, that'd be weird failing of the system almost if that happened.
Yeah. So the language is there, but in practice, on participation, they can't force us.
If sponsors wanted to be very aggressive, could they include that for participations as well? I mean, they could in theory.
They're not counterparty. I'm not in a relationship with them.
They could tell, but the lender of record is, and so what it would say is, Jay, would that work? If they said to the lender of record, if you trade via participation,
so that's what they do in Europe. That's how they enforce the white list.
Right.
They don't allow participation.
Yeah. So that could be something that would obviously be a totally radical change to how we do things, but that would in theory be something they could do if they were actually trying to do what they say they're trying to do versus perform.
In theory.
So you're still part of it, but you have absolutely no real rights. Is that the conclusion?
Well, I think what we're saying is it would say that you cannot sell by participation, or you cannot sell by participation to someone who's on the DQ list. And if you do, then.
But I put a bank in between then.
Right.
Let Goldman go buy it.
Right. And then you have
I would trade
with
participation with Goldman or do it on swap.
Yeah. Yeah.
So if you were advising a client and they said, we want to get in here, or we're currently in here, but we're already DQ'd, would you tell them to try and sell it? Like, what would your advice be? Or you think that,
like, as Jason says, there are plenty of ways to still get economic exposure to a loan without becoming the lender of record. So if you're, and every institution has different threshold and willingness to do that. But certainly many of the institutions that are on the list have a willingness to do that because they're smart, aggressive investors. And so I think we do see people do that, and And there are some theoretical downsides, but again, we've not seen those happen yet in the market.
And so, yeah, and do you hold the same view that because of the lack of enforcement, that this isn't even something that you necessarily have to push back on, that this is a sponsor, like this
It's
isn't
good
imagined
to clean it up
sponsor
because
tool.
otherwise when you wind up getting to a transaction that's agreed on, the mechanics of trying to close all these loans in a short period of time is very painful and a lot of friction, a lot of cost. And this stuff just is an overhang. And the loan settlement process is fairly antiquated still, I think.
Mhm.
So having these things cleaned up in the documents, if you can, is a good thing. It's a matter of good housekeeping.
But I want to make one thing clear. It's not just that you're the economic owner, that we're sitting back on the sideline saying, I'm betting if this loan's going to go up or down. I'm not. We're at the table also. Like in practice, that's what I think people
Right,
need
you
to
said
understand.
you were in the steer
The whole point is that you're trying to keep us from the negotiation. But like at the end of the day, the seller has no economic interest in participating in that negotiation anymore. So the ad hoc group, the group that Aiken forms or someone else forms, it's going to have the economic owners anyway.
Correct. We don't, and just to reaffirm what Jason said earlier, when people, we're forming a group and we say, what are your holdings? They say it's 100 million. We don't have access to the lender record. We do sometimes, but it doesn't matter. And we know that trades haven't settled for all kinds of reasons. So we just, essentially the market accepts on faith because people are always, good to their reputation and good to their name, what people hold, and that they are able to speak for and to vote for, essentially. Economic exposure is important, but really what I'm asking for is, can you deliver me consents for that and
Right.
go from there.
Yeah, and although there is workarounds, I do think it is a deterrent. There are funds that say we're on the DQ list or we didn't get the agent's consent, and they will walk away. And so I think it's a balance, right? Because there is some teeth to it that I think the sponsors kind of see, in that there are some funds that if it's not a big enough investment or there's not enough conviction, that they may just walk away because of that.
But most real distressed managers aren't going to care.
Yeah.
So you're reducing liquidity by taking participants out of the market that you probably don't care are in your credit, and you're not precluding the people that you really don't want in your credit from getting in your credit, and being on the other side of the table in the negotiation. That's why I never thought they accomplished what they wanted to accomplish, and I do think they hurt the liquidity, hurt the cost of capital of the borrower.
Jason, if you get a loan on part and not as lender of record, does that hurt your ability to get back leverage or other fund kind of restrictions that might?
It's a good question.
that?
We don't use leverage, so I don't know. But if we're trading it on swap and the name's sitting in JP Morgan, I don't think it would hurt it at all.
Yeah.
So what's next for DQ lists? Do you think that they're going to sort of move to the more Tropicana iteration, or do you think they're going to move more towards Pretium, where they're just going to like have 100 lenders on a list and then maybe remove if they feel like you're playing ball? Or
Yeah, I think, look, from a macro perspective, as I said, this is another arrow in the quiver that sponsors and companies have to try to get outcomes of their engagements with their lenders to be what they want, and lenders pushing back on it, or it's just another point they can push back on. This isn't nearly as important, I don't think, as the anti-co-op provisions, for example. This isn't as important as shutting down baskets in tight or not tight LME language, depending on where you sit on that. Not as important as very good CERTA J-Crew protection otherwise. But it is something that it does take a lot of mind share for some reason, and the settlement of these things takes a lot of mind share, and you have the middle office involved, and it's just a lot of emails. Frankly, I'll say, if nothing else, a massive amount of emails. And you're trying to close one of these LMEs with a big cap stack and hasn't had any settlements for 2 years. That's so it is, but I think it is not as important as those other points that I mentioned as far as the overall struggle between lenders and sponsors and companies around the debt documents.
Yeah, I think the next step is also, we've seen the addition of a bunch of people on DQ lists, but sort of that last part, the ramifications, actually using the tools to the fullest extent and enforcing people to trade while they're in the middle of negotiations, or using it as a Yanka bank. I think that would be the next step if that's something that happens.
So
has that been threatened on any deal that you've been on, that they're actually going to enforce it?
It hasn't. Yeah.
So what do you think will happen if someone tries to retroactively DQ someone that's already a lender of record?
If it's in the right. So that's the question: is if it's in the loan document,
litigated.
If it's in the loan documents in the four corners of the document versus what appears to be the patent unfairness to your point.
Is that commercially reasonable?
Is it Sure. I mean, it could be commercially reasonable for a borrower. It could be for a borrower to take that action if they had a reason, and it's in the document.
Force you to sell at a loss?
I mean, yeah, it's a good question. I don't know his answer.
Also, how does that work? Like the borrower itself is buying it back from you at a loss, and then they're free to do with that loan.
You could say whatever you want in the document.
Yeah.
Right.
You could say at prevailing market prices. You could say at 80 cents. You could say
at half prevailing market price. You can say whatever. I mean, we're all familiar with the par Yank Bank, and that's just the words in the document of par. If it was 90, it could be 90 cents. It could be if 90% of the loan says yes to an amendment that people that don't can get bought out. I mean, there are a lot. You can do this any way you want, right? Creative finance lawyers can put whatever words they want in the documents, which the last 5 years.
But this whole like reasonably, will not be reasonably denied. The consent, it's never been challenged.
Right.
We looked at challenging it once. It was a Carlyle deal up in Canada. They wouldn't close our trade, and we talked to the lawyers. They're like, what are your damages? Like, you're trading up participation. Like, it's probably
you can vote anywhere and you can vote anyway, as you said.
It's not really worth it. It's not worth your time. So these things, I don't think that best of my knowledge, this has ever been litigated. But if you force someone buys a loan, they're not on the DQ list, you DQ them and force them to take a loss, that'll be an interesting case.
That will be litigated.
Those are clear damages.
Yeah, that's quantifiable to the penny.
And so the same question to you. What do you think is next in the world of DQ?
I mean, these things aren't going away. They've been around forever. I think that how they've been used has evolved. I don't think, a sponsor, Carlyle, is not going to get on this podcast and be like, oh, let's stop using DQ lists because Mudrick told me they're pointless, right? Like, they're not going anywhere. I just don't really think that they do what they're expected to do.
Makes sense. Is there anything that you guys think is sort of the next more effective DQ list coming that will be prevalent in this LME world, or is it just more anti-co-op?
The anti-co-op.
Anti-co-op.
Yeah.
That's the ball game this year.
That's coming.
That's 2025's ball game.
We'll have you guys back on next year for
we
it.
tried hard to organize in Warner Brothers. Couldn't quite get there.
That'll get litigated.
Yeah, but it will get litigated. But again, if it's in there from syndication and it's there and language is clear, it depends how vague it is. If it's like cannot talk, but if it's like can't sign a co-op agreement, I don't know.
And is the enforcement for that also the Yank Bank?
Well, that's a great question. We haven't seen, I guess, it just said in Warner Brothers, it was just cannot, and it was anti-boycott. They used a different phrasing. It was just cannot. There was no, I'm not sure there's specific enforcement, but it could absolutely be Yankee Bank, yank half the banks. I mean, I don't know what they're going to do with it, but yeah, that's still TBD. It hasn't cleared yet in the way that we fear. So we'll see. I'm sure folks have good language in the drawer for that.
Interesting. Well, thank you guys so much for joining me. I think this conversation was very interesting, and the way that I think about DQ lists will be a lot less intimidating than previously.
Yep.
But yeah, thanks again.
Thanks for having us.
Thank you.
And if you have any questions, feel free to reach out to podcast@9fin.com. Thank you so much for listening.